Thank you, Mr. Speaker. Ordinarily, as you better than anybody know, or as well as anybody knows, that I often will say it's a pleasure to rise on behalf of the people for Kamloops, Thompson, Cariboo. It's ordinarily how I start out my speeches, but I'm not going to say that today because this is not something I relish, frankly, rising on a point of privilege. Mr. Speaker, I'm rising on a question of privilege concerning an effort by the Attorney General of Canada to retaliate against me in my eyes, or in the lexicon of parliamentary privilege, to intimidate me for sharing and supporting my party's position that the toxic mix of overlapping conflicts of interest involving the former special rapporteur required the calling of a public inquiry and his dismissal, as was voted on by our House. During Thursday afternoon's question period, my colleague, the Honourable Member for Leeds, Grenville, Thousand Island, Rideau Lakes, asked this question at 2:46 p.m. Quote, Mr. Speaker, it seems to be a comprehension issue for the Minister.
Speaker, it seems to be a comprehension issue for the Minister. The question is about conflict of interest, and it's levels with this government. We have the Prime Minister who hired his friend to pay him $1,500 a day. That friend then hired Trudeau Liberals. He hired from the Trudeau Foundation Frank Caputo. He hired Liberal insiders like Sheila Block, and now we have this rapporteur who's taking the same communications advice as the member for Don Valley North is getting. It's conflict of interest after conflict of interest. Fire the rapporteur, call a public inquiry. Will they do it today?
Will the Liberals do it today? End quote. I pause here, Mr. Speaker, to note that the member from Leeds, Grenville, Thousand Islands, and Rideau Lakes asked another question, but it wasn't related to Justice Caputo in any way. I stood, along with many of my colleagues, to applaud that question, as I agreed that there should be a public inquiry called. It zeroed in on a genuine issue of foreign interference that our nation is currently dealing with. Of course, since Thursday, things have changed now with Mr. Johnston's resignation. I now return to the events of Thursday. The Attorney General sent me an email stamped at 2:49 p.m., and I note that my recollection is that the member for Leeds, Grenville, Thousand Islands, and Rideau Lakes spoke at 2:46 p.m., so 3 minutes later, and it said, quote, see you clapping on attacks on Frank Caputo's integrity. I will let the community know, end quote. This was not a situation wherein the Honourable Attorney General spoke to me privately after question period or sent me a note asking to chat. It wasn't a casual text or even a note signed with his initial or his first name. It was simply a signature block that says this was from the Minister of Justice and Attorney General for Canada. Typically, obviously, in this House, I will speak with anybody at any time when appropriate. The message might sound innocuous enough, but I worry and I do not take it that way. I reacted to a question put forward by one of my colleagues. The Attorney General said he would take action by letting the community know. So the question I have is, what action to whom? The community in question is presumably the legal community. We're both obviously from legal backgrounds. But this doesn't matter whether he's referring to the legal community, the Italian community, or my home community of Kamloops, Thompson, Cariboo. I have 2 law degrees, I was trained as a lawyer, and I currently have a non-practicing status with the Law Society of British Columbia. I served and was proud to serve the people of British Columbia as a former Crown prosecutor, and like the Attorney General, I taught at a law school. I tried to teach students to weave ethics into their everyday decision-making as a lawyer. I believe that this is our role as lawyers, and I know that the House of Commons is different, and sometimes we will do things differently here, but it was something I really did strive to do, and that was the feedback I did receive from my students. I hope and presume that the Attorney General did the same when he taught students in his prior career. So what is this about? I take this to be about reputation. The Attorney General did not like that I clapped in response to a question. He said that he would let the community know, presumably the legal community. And I pause here to note, Mr. Speaker, that a lawyer's reputation is really everything. I may go back to the practice of law. I am still a non-practicing member. I'm less than 44 years old. There's a lot of time left in my career. I have therefore concluded that the Attorney General communicated that my reputation would be damaged and that he would be the communicator of the information to do so. This is problematic on two levels. First, there is an issue of parliamentary privilege, which I'm raising now to you, Mr. Speaker. Second, in my view, the Attorney General got this wrong. The question did not question or impugn the reputation of Justice Iacobucci. I'll be very clear. It called on him as a member of the Trudeau Foundation, which I understand to be a fact. I don't know Justice Iacobucci. I have never met Justice Iacobucci. I have always respected Justice Iacobucci. We cannot forget the dynamic here. The Attorney General is a third-term parliamentarian. He has been a minister of the Crown for longer than I have been elected. He decides serious justice matters. He makes all federal judicial appointments. He is senior to me at the bar by nearly 2 decades. This is my first mandate. My party is not in government. To be direct, this is the Minister of Justice and Attorney General, and he is telling a non-governmental MP that he will take action to diminish another member's reputation in the community. Surely he is aware, or should be aware, that his word as Attorney General will have significant weight. That is a problem on many levels. This behavior, I respectfully put forward to you, Mr. Speaker, is a misuse of his office as the country's top lawyer. House of Commons Procedure and Practice, 3rd edition states at page 107, and I quote, "In order to fulfill their parliamentary duties, members should be able to go about their parliamentary business undisturbed. Any form of intimidation of a member with respect to the member's actions during a proceeding in Parliament could amount to contempt," end quote. This is a long-standing and well-established principle in the law of parliamentary privilege, tracing its roots back to an April 12, 1733 resolution in the British House of Commons. Quote, the assaulting, insulting, or menacing of any member of this House I'll just change the wording, in their coming or going from the House or upon the account of their behavior in Parliament is a high infringement of privilege of this House, a most outrageous and dangerous violation of the rights of Parliament, and a high crime and misdemeanor, end quote. Bosk and Gagnon observe, again at page 109, in order to find a prima facie breach of privilege, the Speaker must be satisfied that there is evidence to support the member's claim that he or she has been impeded in the performance of his or her parliamentary functions and that the matter is directly related to a proceeding in Parliament. In words endorsed by the Speaker in a landmark ruling on May 8, 2023, endorsing, as I understand it, the words of Mr. Speaker Lametti, said at page 6709 of the debates on September 19, 1973, that he had, quote, no hesitation in reaffirming the principle that parliamentary privilege includes the right to be a member of and to discharge his responsibilities as a member of the House free from threats or attempts at intimidation, end quote. Meanwhile, on May 1, 1986, Mr. Speaker Bosley held at page 12847 of the debates, quote, if an honourable member is impeded or obstructed in the performance of his or her parliamentary duties through threats, intimidation, bribery attempts, or other improper behaviour, such a case would fall within the limits of parliamentary privilege, end quote. Bosk and Gagnon explain at pages 81 and 82, quote, the House of Commons enjoys very wide latitude in maintaining its dignity and authority through the exercise of its contempt power. In other words, the House may consider any misconduct to be condemned and deal with it accordingly. This area of parliamentary law is therefore extremely fluid and most valuable for Commons to be able to meet novel situations. Throughout the Commonwealth, most procedural authorities hold that contempts, as opposed to privileges, cannot be enumerated or categorized. The United Kingdom Joint Committee on Parliamentary Privilege attempted to list some types of contempt in its 1999 report: assaulting, threatening, obstructing, or intimidating a member of the House, a member or officer of the House in the discharge of their duties; assaulting, threatening, or disadvantaging a member or a former member on account of the member's conduct in Parliament. While I hope to enjoy my electors' confidence for many years to come, Mr. Speaker, I am also young enough that I could find myself back practicing law before I retire, or even by choice after retirement from this House or after any election that could come. That's the case for anybody here in this place. Remaining in good standing within the legal community is central to that potential path. An attack on my integrity impedes me as a parliamentarian, as a future practicing lawyer, and as a non-practicing lawyer at this time. It's my view the House must take a firm stance against actions like this, and as the defender of the House's rights and privileges, it falls to you, Mr. Speaker, to signal that this kind of conduct will never be tolerated here among honourable members or among the Honourable Attorney General. Mr. Speaker, I don't relish this one bit. I never thought I would have to rise on a point of privilege. I certainly don't enjoy doing this. But this email struck me, and I felt it was inappropriate. And if you agree with me, Mr. Speaker, I'm prepared to move an appropriate motion. Thank you.
So, a couple comments on this. I'm just wondering, I probably should hear from the government member first. So, the Honourable Parliamentary Secretary, the Government House Leader.
Yes, thank you, Mr. Speaker. Right offhand, I would categorically deny what it is that the member is actually trying to imply with his statement. But I will take note in terms of what the member has said, and then come back to the House, Mr. Speaker, at this time. And if we're going to continue to have a discussion, if members can be better focused on what the actual privilege is.
Okay, the Honourable Member for the Honourable Whip of the Official Opposition.
Well, thank you, Mr. Speaker. There is no implication here, Mr. Speaker. It's very clear what happened. I happened to be sitting beside the member when he received that text in real time from the Minister of Justice and Attorney General for Canada. He is a member of the Law Society of British Columbia, as am I, Mr. Speaker, and we both have had legal careers before, during, and after this place. And just as the member mentioned, there was a time when I was not re-elected to this place in 2015, and I returned to my profession and then came back again in a subsequent 2019 election. If a member of the Law Society, if a member of the legal profession does not have their integrity and their reputation, they have very little, Mr. Speaker, because these things for a member of Parliament are extremely important, but they are also extremely important for a member of the legal profession, members of their respective law societies. It is, in my case, I am also a King's Counsel. I've also been a Minister of the Crown. So I understand the duties of a Minister of the Crown, and I very much understand the duties of the Minister of Justice and the Attorney General of Canada, having been a Parliamentary Secretary of Justice myself, and understanding that as the Attorney General of Canada, that is the most prominent position that a lawyer can hold in this country. And to uphold the integrity of that office must also be to treat other members of this House as honourable members, and to think, even contemplate, that the Attorney General of Canada would threaten the reputation of an honourable member of this place, and knowing that it would not just reach this place, but could reach into the outer profession, into his life following his time in this place and during his time in this place, is egregious. And for the member opposite to suggest that it's not what it says, I have read the message, I have read the email. In real time, sitting next to the member, my reaction was exactly his, that the Attorney General of Canada is threatening to harm harm the reputation of a sitting member of this House because he stood in his place and clapped for a member of his caucus during debate, during QP, and this is a fettering of his privilege. This is a fettering of his ability to vote and express himself in this place as a member of Parliament. It is not implied, it is explicit, and it is beneath the dignity of the Attorney General of Canada and should be sanctioned. Yes. Thank you, Mr. Speaker.
I believe the Honourable Opposition House Leader.
Mr. Speaker, I just want to add a few brief comments to my colleague's intervention, because I think it's very important to underscore the way in which this message was transmitted to my colleague. We've all been in the House where people say things, where emotions might get the better of us, and you might chalk something like that up to a heat of the moment exchange. But what the Minister of Justice did was put that message, intimating a threat to my colleague's reputation, his standing in the legal community, and then signed his full signature block to it. In other words, Mr. Speaker, it wasn't just a message from one colleague to another or from one opposing side to another. This was a message delivered by the Minister of Justice and Attorney General of Canada. That is what was at the bottom of the email. In other words, he was exercising an action with his Attorney General hat on. That was him in his office as Attorney General, the highest legal office in the land, and as Minister of Justice. That's the context in which it was sent. It was an official communication from the member acting in his capacity of Minister of Justice and Attorney General of Canada. Don't take my words for it. We will table the email so the chair can see what was said and understand the point that we're making. And I want to just make a comparison, if we could imagine a similar scenario. Imagine we do have members of this House who are currently, or before they were elected, were in the armed forces. Some of them may have intentions to go back to the armed forces. We have a colleague who's a reservist. Imagine the Minister of National Defense writing in the capacity of Minister of National Defense a similar message to a member saying, I saw your actions in QP, or I noticed something, I'm going to make sure the rest of your fellow service men and women know what you just did, or based on what you just did, I'm going to make sure that your regiment understands what just happened. As Minister of National Defense. Egregious, Mr. Speaker. That's the context in which we are raising this point. I also want to make the point that increasingly in Canada, it is these threats of disciplinary actions that are increasingly becoming the fashionable way of imposing political uniformity, of enforcing political viewpoints within the country's self-governing professions. Members of the Ontario Bar have, over the past half-decade, been having a back-and-forth battle about whether to oblige lawyers to adopt statements of principles, whereby they must profess to hold certain beliefs, whether or not they actually do, failure of which would lead to disciplinary hearings. We all know what's happening to well-known commentator Jordan Peterson, who's defending against disciplinary proceedings with the College of Psychologists of Ontario, for, among other things, retweeting the Leader of the Opposition and posting criticism of the Prime Minister's former Principal Secretary, Gerald Butts. But let us not mistake the power and gravity of an Attorney General's efforts to stir up a disciplinary complaint from within the legal community. An Attorney General isn't just some random person or a random lawyer or even a random Liberal off the street who might muse about such things. Any lawyer who aspires to a judicial appointment to a Superior Court, the Federal Court, Court of Appeal, or even the Supreme Court of Canada must have the favourable recommendation of the Minister of Justice and Attorney General of Canada to advance through the Cabinet appointment process. So, Mr. Speaker, I just want to add a couple of points. Paragraph 15.14 of Erskine May 25th edition says, to molest members on account of their conduct in Parliament is also a contempt. Threatening a member with the possibility of a trial at some future time for a question asked in the House, or proposing to visit a pecuniary loss on them on account of conduct in Parliament have all been considered contempts. To attempt to intimidate a member in their parliamentary conduct by threats is also a contempt, cognate to those mentioned above. Actions of this character, which have been proceeded against including impugning the conduct of members and threatening them with further exposure if they took part in debates, summoning a member to a disciplinary hearing of their trade union in consequence of a vote given in the House, end quote. It is a well-established principle that witnesses appearing before parliamentary committees largely enjoy the same privileges as members. The jurisprudence concerning witnesses threatened for their participation at committees would also be relevant to consider in the circumstance. Indeed, in our own House, Mr. Speaker Fraser on December 4th, 1992, at page 14631 of the debates, found a prima facie case of privilege after the Canadian Broadcasting Corporation threatened a witness with a lawsuit concerning the evidence she gave to a subcommittee. Erskine May 25th edition, meanwhile, explains that paragraph 15.21, quote, on the same principle, molestation of or threats against those who have previously given evidence before either House or a committee will be treated by the House concerned as a contempt. Such actions have included censure, punishment, or dismissal by an employer. In relation to that latter proposition, I would refer the Chair, for example, to paragraph 40 of the 5th report of the 2003-04 session from the UK House of Commons Committee on Privileges. Quote, we do not accept Mr. Hewson's evidence that Ms. Wilemski's evidence to the Constitutional Affairs Committee was not, quote, the final straw. Mr. Hewson, with the active encouragement of the majority of the board, sought to initiate the formal disciplinary process against Ms. Wilemski after the 17th of June board meeting as a result of the evidence she gave to the Constitutional Affairs Committee. We do not believe that a code of conduct or board rules can override the rights and obligations of witnesses to select committees, a view in which we understand the Attorney General concurs. Mr. Hewson's attempt to call Ms. Wilemski to account for the evidence she gave was, in our view, a contempt of the House. I see that you're encouraging me to wrap up my remarks, Mr. Speaker, so I will just conclude. I would argue that the Justice Minister's intention is patently clear. Disciplinary proceedings will be encouraged to be brought against my colleague because he dared to speak out or show support to the Conservative Party's position that the Liberal government's special rapporteur process was a monstrosity of compounding conflicts of interest. The House must take a firm stance against egregious actions like this, and as the defender of this House's rights and privileges, it falls to you, Mr. Speaker, to signal that this kind of conduct will never be tolerated here among honourable members. Thank you very much for considering the opposition's points on this.
I thank honourable members for bringing this issue forward. We will be reviewing it closely and getting it back to the House as soon as possible on the findings of our review.